It's my pleasure to introduce you to Dr. Priscilla Mifsud Parker. She is the partner at Chetcuti, Cauchi Advocates for Families and Wealth. And today we're going to be speaking about two very interesting subjects which have really helped to put Malta at the forefront as a financial services centre. These are trusts and foundation. So Malta has actually been very proactive with legislation on both trusts and foundation, but perhaps you could actually start by explaining the effective difference between a trust and a foundation.
Yes, definitely. Malta has been at the forefront of adopting both institutes, and we are, in a sense, very lucky to be able to structure and implement solutions for clients using both of these institutes. The trust itself is more of an arrangement, so it is an arrangement between three parties essentially. There's the settlor involved, there's the trustee, which is in Malta an authorized trustee, so the company or the person would be authorized or recognized by the Malta Financial Services Authority.
Which is the regulator
exactly.
For Malta, yes.
Exactly, and then you have the beneficiaries in that scenario. In the case of foundations, we have, let's say, we use different jargon, so we have the founder, who is the person who starts off the foundation, and then we have the administrators of the foundation, which are very similar to directors in a company. That's in terms of their role. Then, similar to the trust, we have the beneficiaries as well. The main differences between the two vehicles center around essentially their characteristics. So the first difference between trusts and foundations is the fact that one does not have separate legal personality, whilst the foundation has legal personality. The trust itself is represented by the trustees. So the trustees are the owners of the assets which are settled by the settlor, whilst in the case of the foundation, the administrators of the foundations are not the owners, because the foundation itself is sort of a container which has separate legal personality, and therefore of itself it can represent itself. It has its own obligations, its own duties and its own rights. So that is one of the main differences. Another difference is how we register them and the requirement of registration. So in the trust scenario, we do not have an obligation to register them anywhere. So they are set up by means of a trust deed or a unilateral declaration where the trustee declares that he is holding assets on behalf of and for the benefit of beneficiaries. And the trust essentially is not registered with any authority. Whilst in the case of foundations, we have to appoint a notary to have a notarial deed drafted, or else it is set up by means of a testamentary will. And in that case, in order for it also to have officially legal personality, we need to register the foundation with the registrar for legal persons. Exactly. So they are very different in that sense. Another issue that we usually speak of with clients in terms of the differences between them is the issue of settlor or founder control. In terms of the trust, settlor control can be achieved via various means. So the settlor can reserve some rights and some powers for himself in the trust deed, but we need to be careful as to the extent of these rights and powers.
Which is obviously where your advice would prove invaluable.
Exactly. Another important point to mention is the fact that trustees in Malta are regulated and heavily supervised by the local authority.
They've got a tremendous amount of power, so
yes,
they would need to be scrutinised.
Well, they are both instruments which we use for asset protection and also estate planning purposes. So they are very interchangeable in that sense. We use one or the other depending on the client's situation. So in certain scenarios, we would need to use the trust for transparency purposes, because since the trust does not have legal personality, it has a flow-through effect. Whilst in the case of a foundation, we say that it is more of an opaque institute because it has separate legal personality and therefore it doesn't flow through. In the case of the trust, it does.
We're talking about assets, but these of course are not a set piece. They are things which may change. How does this work in a cross-border situation? I'm thinking about, for example, retirements and cure-ups.
Well, in Malta we are very open to the commercial use of trusts and foundations because the law allows us to make use of them. So for example, in the cure-up scenario which you mentioned, we in Malta are an alternative jurisdiction to other jurisdictions, and the law and the way it was drafted allows us to make very efficient use of them in other scenarios as well. So for example, if we were to mention the commercial trust use, where basically banks nowadays, instead of taking a hypothec over property, would in some transactions set up a trust for that particular purpose, hold an asset in the trust, and rather than having to enforce the hypothec on the asset, they would actually already have the asset in ownership. So it makes it much more smooth.
And of course, because Malta is in the EU, these are situations which are affected across borders now.
Yes, and legal regulations in other jurisdictions are nowadays very close to one another because the regulations and directives are obviously very harmonized.
So Malta has become a financial services centre with a great reputation, thank goodness, with a nice stable political and economic climate, and also very nice weather to come and see for yourselves. Thank you very much.